TCC Judgment 113 Champagne 10, 2024, Case on the Standard for Medical Fees. High Notes. Article 21, 22, Paragraph 2 of the Medical Care Act, which stipulates the competent authority for determining the standards of medical fees and the prohibition of unauthorized or excessive medical charges, do not violate the principle of clarity of law. Under current medical practice, it is comprehensible and foreseeable for the medical institutions that, first, the term standard of fees, other than simple items and prices, also includes fees for medicaments, treatments, and facilities, and that, second, multiple authorized medical treatments or procedures charged upfront is an individual kind of charge item under Article 22, Paragraph 2, thus requiring authorization. The said two provisions under Article 11, Paragraph 3 of the Enforcement Rules of Medical Care Act are proportionate to protect the people's right to health and to reduce the information asymmetry between patients and medical service providers. The provisions also do not violate the doctor's freedom to practice an occupation and the freedom of contract under Article 15 and 22 of the Constitution. Background note. Article 21 Medical Care Act hereinafter, Provision 1 stipulates that standards for medical fees charged by medical care institutions shall be determined by the municipal or county competent authority. Article 22, Paragraph 2 of the same Act hereinafter, Provision 2 stipulates medical fees charged by medical care institutions shall not violate or exceed the standard for the fees, nor shall medical institutions charge for items without authorization. Charge for items without authorization is prohibited. Enforcement Act. Enforcement Rules of the Medical Care Act, Article 11, Paragraph 3, stipulates that the term authorization under Provision 2 means the authorization following Provision 1. Per competent authorities, without authorization, charging prepayments in the name of pre-ordered medical treatment or procedures violate the said provision. In other words, medical care institutions shall not request prepayments for their services unless authorized to do so by competent authority. The petitioner of this case is a doctor at a private clinic which was reported to the Department of Health of the Taipei City government for charging an upfront payment for 6 laser hair removal sessions. The Department of Health fined the clinic $50,000 for violating the Medical Care Act. After unsuccessful administrative appeal and judicial litigation, the petitioner filed a constitutional complaint against the court's final decision, calling for a review on the constitutionality. The pertinent regulation. The petitioner mainly argued that, first, relevant medical care laws did not explicitly prohibit medical institutions from charging for multiple authorized medical treatment or procedures upfront, which violated the principle of clarity of law. And second, even if the provisions were explicit enough, the burden imposed on petitioner to obtain authorization disproportionately restricts their freedom to practice an occupation, particularly when it involves only a different payment option for authorized medical treatment or procedure. Summary of the judgment holding. 1. Provision 1 provides that the standard for medical fees charged by the medical care institution shall be determined by a municipal or county competent authority. Provision 2 provides that the medical fees charged by a medical care institution shall not violate or exceed the standard for the fees, Nor shall medical institution charge for items without authorization. Reading the two provisions conjointly, the term standards for medical fees and the charge items do not violate the principle of clarity of law. Provision 3, which stipulates that the term charge for items without authorization under Article 22, Paragraph 2 of the Medical Care Act shall be construed as charging fees that have not been authorized by Article 21 of the Act. And the Provision 1 and 2 do not violate the principle of proportionality. Freedom for the medical institutions to practice their occupation, and the freedom of contract under Article 23, 15, and 22 of the Constitution. The petitioner's constitutional complaint shall be dismissed. Reasoning. Reading Provisions 1 and 2 conjointly, the term standard for medical fees and the charged items do not violate the principle of clarity of law. The legislator stipulated Provision 1 to prevent medical institutions from obstructing patient rights by inflating charge and overbilling. Said provision also protect the healthcare industry's development by preventing unfair competition. Provision 1 required the medical institution to request prior authorization from local competent authority on the medical service fees they plan to provide. It also authorized the authority to determine standard for medical fees when reviewing such a request. Based on Provision 1, legislator also stipulated Provision 2 and 3, which prohibited the medical institution from violating the determined standard. Charges unauthorized under Provision 1 constitute exceeding standards or charging for unauthorized item under Provision 2, which shall be fined. Provision 1 and 2 combine form the regulatory framework for medical fees. The clarity of this regulation should be reviewed in the context of Provision 1 and 2 conjointly, and judged from the professional understanding of the regulated entity, i.e., the medical institution. It can be known from the Provision 2 that the scope of standards for medical fee under Provision 1 includes the monetary payment and the item charge. In addition, under common sense, the scope also includes the medicament fees, treatment charges, and the facility expenses that are necessary for medical institution to run and manage its practice. In this sense, the scope of the term standards for medical fee is foreseeable and comprehensible for the regulated the medical institution and may be reviewed by the court through legislative interpretation in general. Although patients undergo the same medical treatment multiple times, they may display different reactions due to their biological differences or other factors such as environmental influences. To achieve the optimal therapeutic or corrective outcome, medical service provider must examine and treat each patient on a case-by-case basis during each session, even where the same medical treatment must be repeated multiple times to achieve its purpose. That the appropriate time of such a procedure must be decided at the outset of the treatment. Decisions still rely on medical custom recognized within professional field. This is because there is a significant information asymmetry in medical knowledge between practitioner and patient. The term violate or exceed the standard for the fee and the charge for items without authorization under Provision 2 concern not only the issue of whether a single charge exceeds the scope authorized by local competent authority. From the perspective of a medical profession, the term charge item should also encompass the frequency and the fees in instances where the medical science or customary practice require repeat treatment for which fees may be charged upfront. Therefore, such prepaid charges shall gain prior authorization. This requirement is foreseeable and comprehensible for the regulated and may be reviewed by a court. Actually, there were also medical institutions that filed for prior authorization for such types of charges. Provision 1 and 2 conform to the principle of clarity of law. Provision 1, 2, and 3 do not violate the principle of proportionality, freedom of the medical institution to practice their occupation, and the freedom of contract, which enshrine in Article 23, 15, and 22 of the Constitution. Provision 1, 2, and 3 impose a certain degree of restriction on medical institutions' freedom to practice and their freedom to form medical service contract with their patients. This kind of restriction shall be of legitimate public interest. Its means shall be rationally connected to the purpose. Otherwise, it would be unconstitutional. The legislator conferred the competence to pre-authorize medical fees standard to the local authority, specifically because the medical knowledge and the practice are highly professional and technical. There is a high-level information asymmetry between medical practitioners and the patient. Therefore, it is hard for people with no medical background to determine whether the charge and the payment terms for medical service are reasonable. The price of medical service also concerns the patient's financial ability to afford treatment and whether they can regain their health through them. In order to provide a minimum level of protection for people's right to health, the state imposes restriction on medical institutions when drafting relevant legal framework. This restriction requires medical institutions to apply for prior authorization for their charge item and the scope of charge. The purpose of Provision 1, 2, and 3 is therefore of legitimate public interest. Prior authorization under this provision are reviewed and decided by local competent authorities with medical background or by medical review committee set up by local authority and comprising medical professionals. Such a measure takes into account the reasonable rights of the medical institution. It also helps reduce the information asymmetry, prevent unreasonable medical charges, and protect the patient's right to health. It is sufficient to say that there is a rationale connected between the measures set out in Provision 1, 2, and 3 and the purpose of this provision. 3. In terms of the constitutional complaint of the petitioner's final court decision, Provision 1, 2, and 3 cited in the disputed decision are constitutional. The legal opinion in the said decision, including the part that cited the disputed letter, does not demonstrate an erroneous understanding of people's fundamental rights. Nor did the decision fail to consider or demonstrate apparent flaws in weighing the conflict of relevant fundamental rights. Therefore, the petitioner's constitutional complaint is meritless and shall be dismissed.